couple of things. First of all, that just call them the moms they're present in the courtroom. I know you addressed the court the last time and we adjourned it out for reasons. Was there anything else either of you want to tell the court? Again, you can most certainly can address me again. I want to make sure you get.
Most part, the statement that we wrote was kind of addressing everything for all of us. Sherry, the other mom, they had car trouble, so she's watching it on your YouTube.
Oh, okay, very good, very good. All right, so there was nothing else you wanted to indicate. But let me say a couple of things to you so that you kind of understand, and if you want to address the court after I say what I say, then certainly you may. First thing is that court went back and I reviewed the police report and other documentation that was given to me because there were two sort of versions of events which would lead me to different conclusions. One version of the events is that Mr. Torres was nowhere near the accident scene at the time. My position initially on reading the initial reports in this was that, okay, he may not have been, but the cause of the accident was because of what had transpired. Now, part of my initial analysis of that would have been what I understood at the time to be his proximity to the accident. Right. There was some discussion the last time, I don't know if you recall, but there was some discussion the last time regarding that proximity. There was then also a discussion as to which complicates this matter a bit more, that there are actually two accidents that occurred. There's the initial accident, which was basically the bumping into the rear of the vehicle, the rear end collision, and then the ultimate tragic accident that occurred. That's also part of the complication, okay? The next part of the complication comes in that what the original charges were, what the ultimately pled to, and again, there was certainly advocated by the defense that he should be sentenced in accord with the failure to stop an ID at a property damage accident, as opposed to the other accident. I needed, between the last time that we were here and today, a clarification as to what exactly Mr. Torres pled to. Because again, depending on what he pled to, those lead to two different results. I've had discussions with defense counsel in the prosecutor's office, and my understanding, and counsel can correct me if I'm wrong, that what Mr. Torres pled to was the original fender bender or the rear end collision, and not the ultimate tragedy that occurred in terms of that accident. That further, the reason for that was because of his lack of proximity to the ultimate accident, that the data and other information revealed that he was nowhere near or not at all close to the scene of the accident that occurred. Now, Having said all of that, I will let you know that that changes this court's conclusion about sentencing in this matter. And would certainly cause the court to depart from the recommendation that probation, who I think was under the same assumption that I was under, had come to regarding the sentencing in this case. So, having said all of that, I don't know, and I guess, Mr. Torres, if you could have a seat, folks, I realize one Moms is not here. She's watching on YouTube. If she wanted to sign in and address the court, certainly she may. No, right at the table, right here. I've stated what I've said. Did you have any questions for me? Okay, come, I need you to, it's okay. I figured you might, and so I want to make sure I address the question.
So, one of the questions. Sorry.
Yeah. No, it's okay. Can you state your name first?
Yes, Christy Green.
Thank you. Go ahead.
You're welcome. So when you say like he wasn't, his proximity to the accident, are you talking about the second accident?
I'm talking about the second accident. So,
Okay.
So just so you understand where I'm coming from and what I now
Yep.
see, there's the rear end collision, right? And then after that rear end collision, the first car, which your daughter was in, takes off. That Mr. Torres, as I understand the facts now, goes some distance, but isn't in the area when the accident, the fatality occurs. Which is a whole different impression than what I had initially.
Okay.
Okay, so go ahead with your question. I'm sorry.
Okay. So, are you aware that the first accident, it just wasn't a hit and run? That there was actually video footage that my daughter got out and they went back and forth. They spoke.
You want to take your time, please.
And he took a picture of her license
Hold
plate.
on, I'm going to let her come up with you. And we'll get to it.
Thank you.
Go ahead.
So are you aware that it wasn't a hit and run because there's two different police reports, right? So there's Ypsilanti. Ypsilanti had it as a hit and run, but then there was a fatality through Superior Township, right? So
The sheriff's department, right?
So when they investigated, because we had sat down with the prosecuting attorneys and we went through this and we actually asked quite a few questions when they were originally dropping the charges from the misdemeanors. But they called us in to sit down and discuss all this a while ago. So at that point, we asked quite a few questions. And it's my understanding that from Eastern, there was video footages that see when my daughter hit him, they stopped. They got out of the vehicle, they went back and forth. The detective had Mr. Torres's phone and verified that there was a picture of the license plate that was taken in his phone prior to him chasing them or following them or whatever it is that we're calling that right now. Are you aware of that?
Well, which part? I'm aware. Let me tell you what I am aware of.
Okay.
As at least again, as I understand it, that there's the initial accident.
Yep.
My understanding is that there was some contact between the parties to that.
Okay.
That it wasn't what I guess what one would describe as a hit and run.
Okay.
Somebody took off,
Yep.
right? And again, so that at least you're clear, and I want to be clear as to how I'm looking at it, that what Mr. Torres ultimately pled to was not what it could be a hit and run, but was not a hit and run. It was basically failure to stop at the scene of a property damage accident, because the law requires that certain things have to occur, or the person has to do something
The first
at the
accident.
scene, right?
Okay. So then you said something about the second accident. So all we're talking about is the first accident, because you said he wasn't in proximity of the second accident, and I don't know how.
That's what the data, that's what I see from the data.
Okay, so the first driveway, if you're to pull on that street, he would very clearly been able to see what happened. So I just want to make sure we're not talking about that, because I don't,
See what happened, okay,
the second accident.
the second accident,
Yes. He was with it.
whether or not one could see it or not, he was not in proximity to that accident.
What would you consider proximity?
That he's a distance from that accident.
What just
So what, well, I can't give you I can't lay it out by feet or anything like that, so I can't say that. What my understanding, the facts are, is that he's some distance from when the accident occurs. Now, hold that thought for a moment, okay? Because my initial reading of this was that that the cars take off, right?
Mhm.
And that he is indeed following them, but doesn't stop,
Correct.
right? My understanding is he stops at some point and the accident occurs further down. But at the point that that happens, he's not, what do you want to call it, in pursuit, chasing, following, he's not doing that at that point. That's my understanding now. Now, if you believe that there's something that says something different,
Mhm.
then I certainly want to see it. But that is, when I'm now looking at everything, that's what I see.
Okay, I don't believe his vehicle. I think it was too old to have a black box in it that would show where he actually was.
That's the data from the accident reconstructionist says something different than what my impression was. That's what I'm,
Okay, so then maybe I didn't see that, but the driveway that he clearly stated he pulled in, I would say is 10 car lengths, 10 car spaces from where the accident happened. So you can say close proximity, not close proximity. We could all have a different understanding of that. So I disagree with that statement, because I think it's based on how we would personally look at it. So I just wanted to clarify that, but I don't know that that's going to make a difference in what we're doing sentencing right now for.
let me just tell you this, ma'am. And I'm just kind of a straight shooter about things.
I appreciate that.
This whole case troubles me, right?
Yeah.
And sometimes I guess it would be great doing this job if I weren't a human, because then I don't have to deal with things that I have to set aside in my mind.
I understand.
Parent to parent, I'll just say this. After we were here the first time, I could only think about my daughter. And that I would want something to happen. I'm not even sure I'm not even sure what I would want, right?
Yeah.
But that I would. And I had to kind of, people I think think that when judges leave the bench, we kind of leave everything behind us and we don't think about things. This one has been with me. I want to say a lot, but I think it's been sitting in the background and on just all my thoughts. But I also realized in great part, setting that emotion aside, I realized I had to do my job, right? And I also realized that if I could, but I know I can't, that I don't have the power to bring back who you lost. It, in a lot of ways, sitting here is a helpless feeling because it really doesn't matter what I do.
How I feel.
Hmm?
That's how I feel.
I can't make it right. And I know I can't. I realized that being limited in that regard, that all I can do is try to make the correct decision. And while this may sound crass, I don't mean it this way, but it's the best words that I can come up with, and then let that fall where it may. And the way for me to do that is to try to make sure I have a clear understanding of, as best I can, what happened. If, and I said this before, if my impression that I had initially was that there's the rear end collision, and then at some point this chase happens, and I purposely use that word chase happens, then the consequence of that chase may rest with Mr. Torres, right? That's one scenario. The other scenario is the initial accident happens, and then there may be this brief moment, and you're right, they're out of the vehicles at some point. Then there's this brief moment where the vehicle takes off. He may even be headed in the same direction, but then stops, calls the police. Under that scenario, he wouldn't then be attributable, or it wouldn't be attributable to him, and he wouldn't be the cause of it. When I went back, and like I said, I'm just trying to do the right thing. And when I went back and looked at everything, it's that second scenario that I'm seeing. And if you think that there's something else that I should look, I looked at everything, but if you want me to look at something else before I approach sentence, I will do it. I mean, I don't know that it would lead me to anything different. But I will say this, I also didn't think looking at it again would lead me away from the first conclusion I had. Yeah. Right? But if there's something you think that I should look at, I'll do it. I mean, I'm not, like I said,
For leaving.
In the end, I can't bring your daughter back. I can't bestow upon you just peace and solace, and I can't do that. But what I can do is at least have you believe that somebody looked at it and looked at everything and looked and that you were heard. That I can do. And if that's what you want me to do, I will do it. When they told me, and I know when we adjourned it out, I was informed by the victim's advocate that you guys were on your way and that you were stuck in traffic or something like that. And my words were, we'll wait. I could have gone ahead because you've already addressed the court, but I said, no, I'm going to wait because I want to make sure that they're heard.
Thank you, and I appreciate that.
All right.
Can you grab my phone? I want to make sure that Sherry, she's watching. I want to make sure that she doesn't have anything to say. So the question that you're asking about.
You're in communication with her then?
Yes.
Okay.
Yeah, she's watching on Zoom.
Did she want to sign in? I mean,
that's what I'm trying to find out right now.
Okay.
So the question is for if
Go ahead. You
I
can
want-
message her if you want.
if I want you to look at additional evidence. We're talking about evidence on just the first leaving the scene of the accident. What is being charged for? Is that what you're asking me?
No, what I'm asking you is that if you think that there's something I'm not seeing that would lead me to change my view of now what I have about causation, I'll look at it. I don't have a problem doing it.
Okay.
And so that maybe to better answer your question, it's that period between the first accident and the second accident, that time frame.
Okay. I don't know if you want me to step out and make a call or if you want me to do it from right here.
You want to call her to see?
Yeah.
Okay, if you want to step out, you can make a
Okay.
call. Go ahead.
Thank you.
Sort of briefly pass. Okay, Ms. Smith, try again. Unmute. Let's see if we can hear you.
All right, can I be heard now?
Wow. Okay, remember that. We just learned something today. Okay, Ms. Smith, try again. Unmute. Let's see if we can hear you.
Can I be heard now? I am unmuted.
Yep, I can hear you. Does she have another device?
She had YouTube on.
Oh, you gotta turn YouTube down because otherwise I hear myself twice and I don't even like listening to myself once. So
All right.
I got it? Okay. All right. Now everybody's here. Okay. Did you have a question, ma'am, or something else you want to tell the court? I think you were listening to what I said before.
I would really like for the initial phone report when he called into 911 to be relooked at. Because from my understanding, in that 911 call, admits to the chase. He admits to turning in the driveway before the railroad tracks, and he admits to seeing some dust. So what dust did you see if they're on a paved road and you're not on a dirt road? The dust you saw was them going over them railroad tracks and crashing.
I thought I had seen so what you're asking me, just so that we're clear, you want me to, if it exists still, you want me to listen to that 911 call?
I would love for you to listen to that 911 call. I mean, I know at this point, it's probably not really going to change anything that we're looking at, but at least to get our understanding heard and maybe get a different look at it. It's just, if you're admitting to it and you tell them you turned around in the driveway before the railroad tracks, which is where they crashed, none of it just sits well with anybody.
Okay. Ms. Reiser, does that still exist that the court could get a copy of the 911 call?
Yes, I believe so, Your Honor.
Okay. So you want me to listen to the 911?
Yes.
Anything else you want me to?
I mean, I know in the end, it's like I said, probably not going to change anything, but at least we are heard. At least it makes a difference in my eyes that it's heard and it's relooked at.
Okay. I can't, so that you understand, I'm looking at it for the purposes of sentencing, from my standpoint. I can't change, I don't have the authority to change any charging decision, what the plea was or anything like that. So I want to make sure you understand that that's not why I want to see all of it. I just want to have the correct perspective on it. And if you think that will lead to something where it may change my thought process, then I don't have a problem looking at that, Ms. Smith.
I definitely do.
Okay.
And the only thing that I just want to add is that he had a picture of the license plate from the first accident. When he left, he already had the information he needed
Correct.
to file a police report on it. So that's the only thing I want to add for it.
Okay. So that's the second time that you mentioned that, and I want to make sure I understand what you're trying to tell me on that. So let's say that this picture exists. I'm not disputing that it does. The picture exists on his phone. What do you want me to take from that?
So the charge that you're sentencing on right now is leaving the scene of the accident, the first accident, not the second accident, correct?
Correct.
Okay, so leaving the scene of the first accident, I just wanted to clarify and make sure that we all knew that it wasn't a hit and run because Ypsilanti had that in their police report, and then when Superior Township Sheriff's Department, they clarified that it was not a hit and run. There was a stop. My daughter and Mr. Torres got out. They had a conversation. He went to the back of the truck. He took a picture with his phone of the license plate. There was also text messages that were sent from the accident that was sent to someone saying she just ran into somebody, and he's taking a picture of the license plate. So that's what made us ask the question, and it was verified that they took his phone, just like they took the girls. They had all the phones and evidence, and there was a picture, according to Detective Yee, that he did have a picture of a license plate in his phone. So technically, he really didn't need to leave the scene of the accident. That's what I'm adding to it.
That he didn't need to leave the scene.
He
Okay.
had all the information to make a police report, a proper police report.
Right. But he didn't. That's part that. So.
Right.
Part
So
of-
why did you need to pull off and proceed with the chase when you had all the information?
Well, okay. I hear you, and let's back up a moment, okay? So that you understand. If somebody's involved in an accident, what's really supposed to happen, ideally, is everybody is supposed to remain there and call the police. So what I hear you saying is he could have remained there, but did not.
Mhm.
And had the information that he needed to do the police report.
Correct.
Did I got that?
Yes.
Okay. Right. And I'll probably have to think that through, but I don't know what I would do with that. And the only reason I say that is because I really could say the same for both vehicles.
Well, clearly.
Yeah, that both
Mhm.
should have remained there.
Yes.
Having done this for a while, I can tell you that doesn't happen. Usually one is off someplace or nobody does anything. So I mean, I'll think about it, but I don't know really what I would do with that piece, or that I could say.
Can I add something else?
Yes, I just want to, let me just finish this point. I don't know that I could try to sit there and hold Mr. Torres or your daughters to a higher standard than what in practicality happens out there.
Mhm.
Hey,
Yeah, I mean,
but I'll think it through. I mean,
okay.
okay.
Also the the 911 call, I believe. He said he was following them, chasing, whatever the wordage was used. I did not hear the 911 call. But he stated that he was following them, chasing them, whatever, to get their license plate number. Like that was the reason for
Okay,
it.
I see what
And
you're
here you
saying.
had it.
Okay,
So
so
I
what
think
you're
more so
saying
just
is,
pointing that out.
got it. So what you're saying is the picture was already taken.
Correct.
That's how this flows in. Okay, I see. The picture is already taken, but then at some point in the 911 call, which occurs later, he's claiming that he is following them to get the license plate.
Yeah, because of a hit and run.
Got it.
And
Can I
again, I
add
did
one
not,
or ask one more thing?
Yeah, certainly. Go ahead, man.
Through this whole court situation, my surviving daughter has not been spoken to, and even got to tell her side of.
What started as a routine sentencing hearing quickly turned into something much more emotional. The judge revealed that after reviewing police reports, accident reconstruction data, and additional evidence, his understanding of the case had changed dramatically. At the center of the dispute was a critical question. What exactly was Mr. Torres responsible for? Initially, the court believed there might have been a direct connection between Mr. Torres' actions and the tragic fatal accident that followed. But after taking a closer look at the evidence, the judge explained that there were actually two separate incidents. The first was a minor rear-end collision. The second was a devastating crash that ultimately took a young life. According to the judge, newly reviewed data suggested that Mr. Torres was no longer near the scene when the fatal collision occurred. That distinction became crucial because it changed how the court viewed responsibility and sentencing. The charge before the court was no longer centered on the tragic outcome itself, but rather on the events surrounding the initial accident. For the victim's family, however, that explanation raised even more questions. They wanted the court to understand that the situation was far more complicated than a simple traffic incident. They argued that there had been communication between the drivers after the first collision, and that evidence existed showing Mr. Torres had already obtained the information he needed before leaving the scene. As the hearing continued, emotions began to rise. The mothers of the victims respectfully challenged portions of the court's understanding of the timeline. They questioned whether all available evidence had truly been considered and whether the events between the first collision and the fatal crash had been fully examined. Rather than dismissing their concerns, the judge listened carefully. He acknowledged that the case troubled him deeply and admitted that it had remained on his mind long after the previous hearing ended. While emphasizing that he could not change the charges or undo the plea agreement, he made it clear that his goal was to reach the most accurate and fair decision possible. What followed was not an argument about legal technicalities alone. It became a powerful discussion about accountability, loss, and a family's determination to ensure every piece of evidence was heard before the final sentence was imposed. As the hearing moved forward, the conversation shifted from legal procedure to something far more personal. The victims' families explained why they believed additional evidence could change the court's perspective. One of the most significant points involved a 911 call allegedly made by Mr. Torres after the initial collision. According to the family, that recording contained statements that deserved closer examination. They argued that if Mr. Torres already possessed a photograph of the vehicle's license plate, then questions remained about why he continued following the vehicle afterward. To them, that detail was critical because it could help explain what happened in the moments leading up to the fatal crash. The judge listened carefully as the families outlined their concerns. They spoke about surveillance footage, witness accounts, text messages, and investigative findings that they believed painted a more complete picture of the events. Their request was not necessarily to change the legal outcome, but to ensure that the court considered every available fact before reaching a final sentencing decision. Then came one of the most emotional moments of the hearing. The judge openly acknowledged the pain that the families had endured. Speaking not only as a judge but as a parent, he admitted that he had thought about the case extensively since the previous court appearance. He explained that no sentence could undo the loss they had suffered, and no ruling could bring their loved one back. Still, he stressed that the responsibility of the court was to seek the truth as accurately as possible. Even though he could not revisit charging decisions made by prosecutors or alter the plea agreement already in place, he could make sure that his sentencing decision was based on the fullest understanding of the facts. That commitment led to an unexpected development. Rather than proceeding immediately, the judge agreed to review additional materials requested by the families, including the 911 recording and other evidence they believed was important. He ultimately decided to postpone the sentencing hearing, giving himself more time to examine everything before making a final ruling. By the end of the proceeding, one thing was clear. This was no longer just a discussion about legal definitions or technical evidence. It was about a family searching for answers, a judge determined to get the facts right, and a courtroom wrestling with the difficult balance between law, accountability, and justice.